And thank you. My understanding is that the author will accept the amendments suggested in the analysis, which authorize the expansion of transit-based automated enforcement programs on a 5-year pilot program basis, with a report due to the legislature in year 4, which addresses the efficacy of the new enforcement programs, impacts to privacy, which is a concern particularly to this committee, and a cost-revenue analysis as well. Is that your understanding, and would you be willing?
My understanding.
Very good. So with that, good afternoon, Senator, and if you would proceed.
Thank you very much, Madam Chairman and committee members. I do accept those amendments. This is legislation that builds on a program that was a pilot program in San Francisco and since has been made a permanent program, which allows the use of forward-facing cameras to enforce parking violations in this case, bus-only lanes. In California, in San Francisco, it was transit-only lanes, and also at bus stops. The program in San Francisco, which started as a pilot, was shown to have successfully increased bus reliability and reduced the frequency of illegal parking rather dramatically, about 47% decrease in bus zones and, 47 and 44% decrease in parking violations for double parking. It did not raise privacy issues, and it was not a moneymaker for San Francisco. It was a transit improvement effort. And AC Transit is in the process right now of setting up a bus rapid transit corridor and would like to have this ability in place so they can heavily advertise it and have it in place by the end of 2017, when the corridor will be ready to be fully functional. The bus stop provision is for 2 reasons. One is safety. We're finding more and more intrusion into bus stops, very difficult for disabled people, for elderly people, for people who need a little extra time getting on the bus, and obviously when a bus is forced to double park or park outside, it adds to traffic congestion, etc. So with me today in support are Chris Peoples, AC Transit Director, and Carrie Jackson with AC Transit.
Thank you very much. Good afternoon, and 2 minutes each, if you would, to present your positions on the bill as amended, if you would.
Thank you. Chair Jackson, members of the committee, my name is Chris Peoples. I'm an elected at-large member of the HE Transit Board, and I'm serving as its president. With me here today is Carrie Jackson. Carrie is our Director of Protective Services. He's a retired captain from the Alameda County Sheriff's Department, and he will be in charge of this program if it's implemented. So he is prepared to answer any technical questions. Lonnie covered the bill pretty well. We're following up on a very successful Muni program. That 47% decrease in bus zone violations and a 44% decrease in double parking resulted in a 15% increase in transit speeds along some of those corridors. That's pretty important. The bus stop issue is becoming ever more critical. I gave up my car 18 years ago. I only ride the bus. I had a stroke 5 years ago, so I don't walk very well anymore. I can get off a bus if it's not at the curb, kneeled at the curb, but it's difficult, and there's always a chance I'm going to fall. My friends in wheelchairs can't get off at all. With a 4-to-1 ramp on a modern low-floor bus, if you're not at the curb and have that extra 6 inches or so, you can't get off on a wheelchair. So they've got to get off at a stop before or a stop after and wheel the way through. This has become particularly acute with the advent of TNCs, of Uber and Lyft, they are taking our bus stops as places where they pick up their passengers. There's particularly a problem at BART stations. Ironically enough, Saturday night on my way home, there was an Uber car parked in the stop where I get off, right by the Piedmont Theater. The driver pulled up, flashed his lights, honked. The Uber car absolutely would not move. I had to get off in the middle of the street, hobble over to the sidewalk, and I took some pictures, which I would be happy to share with your staff, of the Uber car parked there. What was particularly maddening was right around the corner on Piedmont Avenue, the stops in front of the theater were completely open. So we have 5,800 bus stops, and at any given time, we have 12 sheriffs on duty. So what that means is they don't get caught. So with that, I would urge an aye vote, and Carrie is available to answer any questions that you have.
Thank you very much. Do you wish to speak, or you're just available for technical questions?
Available for questions if
All right.
anybody has any.
Very good. Other witnesses in support?
Good afternoon, Steve Wallach on behalf of the Alameda County Transportation Commission, also in support of this bill.
Very good. Thank you. Other witnesses in support? Any witnesses in opposition? That's refreshing. All right.
Not quite as global as the last one.
Right.
All right. Any questions, comments? Senator Wojciechowski.
I represent part of the AC Transit District. There's concern in the staff report about the angle of the camera, some privacy concerns that we don't want to have these buses wheeling around and taking general video. Or video views of the public. Can you comment on the recommendations in the amendment and how that be implemented to protect against that?
As you know, so we already have forward-facing cameras on our coaches. This would be an additional camera that would monitor primarily just the area where the coach is pulling into, so the bus stop. So it's very much the same method that San Francisco uses. So I don't think that there would be any additional privacy concerns in that respect.
Okay. Any other questions? I appreciate your taking the amendments, and it will accept a motion to pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wojciechowski?
Aye.
Wojciechowski, aye.
That is 6-0. The bill is out. Thank you very much for your presence today. Next item is file item 15 by Senator Hernandez. This is SB 1428. Good afternoon, Senator Hernandez.
Good afternoon, Madam Chair and members. Madam Chair, members, it's becoming an increasingly digital world. Often consumers are able to sign up online for continuous service agreements, but when seeking to not renew, they are frequently required to call a toll-free number. Consumers must then talk to sales representatives, which could prove frustrating and perhaps burdensome. This bill requires that businesses offering automatically renewing or continuing service agreements provide online methods of cancellation to consumers. It could be email or some other method and does not prohibit provisions of a toll-free number for those consumers who wish to call. This bill seeks to provide consumers with options while seeking to protect them from undue penalties and fees. The author amendments that are outlined in the analysis seek to address some of the concerns raised by the opposition, and I appreciate the committee's staff willingness to work with my office. And with that, members, I respectfully ask for an aye vote.
Thank you, Senator Hernandez. Any witnesses in support? Are there any witnesses in opposition to this measure? Good afternoon.
Good afternoon, Madam Chair, members. Steve Carlson for the Direct Marketing Association. Before the amendments, I would have had a lot more company up here, but some of the amendments reflected back to the existing statute, which I would like to speak to, which exempts a number of businesses and industries, including CTIA, another one of my clients. So thank you for that, Senator. But others of my clients still have a couple of issues with the bill. Would like to explain that to the committee. In its original form, the bill said if you entered into a contract online, you had to provide an online method of cancellation. It was changed on Friday, and now says if you have an automatic renew, any kind of an automatic renewal contract, notwithstanding how you enter into that contract, you must provide an online method of cancellation. One of the things I think, and I think the analysis did well, was to talk about existing law with respect to contract cancellations. There's state law on the issue. Senator Yee had a bill, which I think some of you were here back in 2009, and we have a pretty comprehensive prescriptive automatic renewal statute in California, probably one of the strongest in the country. I was happy to be part of that, part of doing that, and it has within it the requirement to provide a simple, easy means of cancellation. There is federal law on the subject, Restore Online Shopper Confidence Act, which also says, among other things, that you have to provide a simple means of cancellation, but it's technology neutral. It doesn't say you have to do it one way or another. It just says it has to be simple and easy, and it is enforceable by state AGs as well as the Federal Trade Commission. So I don't think that there is a lack of existing law if cancellation processes are unduly difficult. We think that there's law to get to that. One of the concerns, I think, with the new language is that it's relatively prescriptive and it doesn't necessarily track existing business models. For example, if you enter into a contract by phone or mail, you will be required, if you will, to enter into a cancellation method that was not previously used by the customer. One of the requirements in the bill is that there has to be a 24-hour notification by email or to the customer. Well, you may not have that customer's email address. The customer would then have to provide that email address at the beginning of the transaction. So, we've met with Senator Hernandez and we've met with his staff, and we think that those are things that are things I think we can work through, but I don't think that the language necessarily reflects business models that currently exist in some areas. So I think we'd like to work with the author on that. Again, not all of our clients have had an opportunity to really vet the language. Again, it was, we saw it on Friday, and we'll have an opportunity as it works through the process. But again, for those reasons, we're opposed unless the bill's amended to reflect, I think, provide maybe a little bit more flexibility in the way these things can operate and reflect current business models. So, thank you.
Thank you. I think that is part of it, and I'll have Senator Hernandez, if you'd like to address it. It just says that it's one of the methods available, not the only one. So I think it will deal with your concern. Any other witnesses in opposition? Yes.
Madam Chair, members, Bernie Orozco with the California Cable and Telecommunications Association. I can spit that out. Want to thank the senator for taking the amendment. We appreciate working with the senator on this. It has addressed all our concerns, so we are appreciative, and we are withdrawing our opposition. Thank you.
Nice to hear. Thank you very much. Any other witnesses in opposition? We can all hope, can't we? All right. So any debate or discussion? No? All right. Senator Hernandez, if you'd like to close.
Yeah, Madam Chair, members, if you think about various products we purchase, whether they're online or you purchase them, I think the thing that frustrates the consumer is the automatic renewal. And especially like I'll give you an example, when I signed up for my cable and it automatically renewed, and all of a sudden my bill just went sky high. Yes, it forced me to call them to try to bring it down. But this was designed to allow consumers that option to do it online, to make sure that they have the ability to either cancel it or to engage in that conversation. And with that, members, I respectfully ask for an aye vote, and I am committed to working with the remaining of the opposition as long as it addresses the intent of the legislation. Thank you.
All right. I'll debate. We have a motion. Is there a motion? Senator Wachowski moves. This is a motion do pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, I. Morlock? Morlock, no. Anderson? Anderson, no. Hertzberg? Leno? Leno, I. Monning? Monning, I. Wachowski?
Aye.
Wachowski, aye.
4-2, that bill is out. Thank you very much. And we'll move to file item 17, which is AB 691 by Assemblymember Calderon. Do we have this taking the notice? All right, before we start, I'd like to just sort of reiterate the amendments that we've been working on. As the committee can see, we've been working on these diligently, but up until the last minute, because we are at the end of our time frame for our Senate bills, and this is on a 2910, so we are hoping that we can resolve the concerns, the various concerns, and I think there have been a number of amendments. So it's here, the bill's here under Senate Rule 2910B. My understanding is that you have agreed to strike out Section 8A2, and that you are also committed to taking an amendment to address the encryption concerns raised in the opposition's letter, and that you are going to continue to work with staff on this amendment.
Yeah.
Is that?
Yeah, that is true. The only augmentation I would make is in terms of the Second Amendment, we haven't agreed to take an amendment. We agreed to work on the encryption issue with the opposition, the current opposition.
Okay, so we have an amendment to address that encryption concern. Are you saying that you're not going to take that?
So under our current concern with the current language of the Second Amendment that's being proposed is that, you know, when we've been in this committee a few times, we've passed this committee twice. This is the third time we've been in this committee. The commitment that we made to this committee is that we were going to work with opposition, something that we've done. We've bent over backwards to work with opposition. The reason why we're back is because in working with that opposition, it significantly amended the bill. Since it significantly amended the bill, what I don't want to do is take an amendment that will blow up the current support for the bill, which is what we've worked so hard to achieve. And so that current language of that amendment, my understanding is that it does that, is that it removes our opposition, and so we don't want to do that, but we're willing to continue to work to try and find language on that encryption side of the issue.
Okay, so I think what you're saying is that the amendment as proposed, it destroys the balance that you've worked on, but that you will continue to work on that. And this is, my only concern is that the bill can only be amended now on the Senate floor. So I'd like to get a commitment from you that you won't bring it to the Senate floor until we have gotten an agreement on that.
No, absolutely.
All right, fair enough then. Good. Very good. So if you would go ahead and proceed.
Thank you, Madam Chair and members. AB 691 will authorize a decedent's personal representative or trustee to access and manage their digital assets and electronic communications. This bill will authorize a person to use an online tool to give directions to the custodian of his or her digital assets regarding the disclosure of those assets upon their death. In the absence of the decedent's use of the online tool to provide that direction, he or she may give direction regarding the disclosure of digital assets in a will, trust, power of attorney, or other record. If a user provides no direction at all, the terms of service or other relevant probate law would become operative in the terms of service if the terms of services are silent on fiduciary access. Most importantly, AB 691 will establish a model piece of legislation to provide fiduciaries a process to gain access to their loved ones' online communications for the purposes of administering their estate. The bill before you today is the product of my effort to address this issue and the concerns raised by the opposition and the committee when the bill passed out of this committee in September. Those who were in opposition to that version of AB 691 are now either in support or neutral. With me to testify and support today are John Doherty with TechNet and Robert Callahan from the Internet Association. Thank you, and I respectfully ask for an aye vote.
Thank you. Good afternoon, gentlemen. 2 minutes each, if you would.
Madam Chair, John Doherty on behalf of TechNet. I appreciate the committee's time, the staff time that we've dedicated to this issue. I want to start by saying the backdrop for the entire bill is a default to privacy, which means that we came forward with the proposal because we were concerned that other proposals were too far in favor of the practitioner and not as much concerned with the privacy of the user. We came before this committee at the end of last year, and different members of different senators also pointed out that there's also a good balance to be struck for the practitioners to make sure that they can succeed and administer the estate in a way that makes the most sense.
And if I may, practitioner is a phrase that refers to either the executor or the trustee of the estate, as compared to the user, who is the decedent usually, or the trustee, trustor actually, and the there are three groups, and I'm having a brain freeze. You refer to yourselves as the provider.
The service providers are the custodians.
Thank you.
The privacy advocates, and then I said practitioners. That includes judges, clients, decedents, and attorneys representing them. And so
that we're all on the same page here in terms of who we're talking about. Okay.
So I just really quickly, when we were given the charge by the committee that everybody thought we were very close with the opposition, what we found out relatively quickly is that the way towards a path that balances all of these concerns was with the national model developed by the Uniform Law Commission. That Uniform Law Commission spent years, more than 2, working on the issue, came out with a revised UFADA to make sure that everybody's interests were taken into account. And so what the bill as a whole does is it says the first thing we need to do is how do we prioritize whether or not a user consented and what does the user want. And the bill very quickly says if there is an online interactive tool that the person used for the service, that's the one that is most likely to be indicative of what the consumer wants, and that should be used. If that has not been utilized, the secondary look at it is what is they've said in their will, trust, power of attorney, or other record. And then either of those can be trumped if there's a term of service contract that has been interactive and the person has been told to do that. And so then what it does is it simplifies a very complicated topic by saying you either are somebody who has prepared for this or not. You either have a trust and a will or you don't. And in either case, what we're looking for is if the user has consented, then only then are you able to give the content that is part of the electronic communication. And so what that means is that if somebody has used the online tool or in fact filled out their will and form, the custodian can hand over the information that actually was the communication. If you don't have that, then what we do is we fall back to passing over the catalog of communication, which is the information somebody would need to know that Wells Fargo or Schwab or somebody else is communicating with the decedent, and you know that as a personal representative or fiduciary, you need to contact them and reach out and find out what that relationship is and whether or not there's an underlying asset. So we believe that the work comes together in a way that protects privacy at the forefront, but makes sure that estates can be administered as efficiently as possible. So with that, we'd respectfully ask for your aye vote.
Thank you very much. Briefly, if you would, sir.
Sure. Thanks, Madam Chair. Robert Callahan with the Internet Association, also in strong support. Do appreciate the committee's time and efforts and the work of the coalition to get this thing right. Echo the comments of Mr. Doherty with TechNet and the author's statements. I would like to say that this bill is very timely. We are at a dynamic and a time in society today where more and more people are passing away having extensively used Internet services. It's yet not ingrained in our culture to be thinking thinking about how those accounts may or may not need to be accessed as part of administering their estate, and there remains a lack of clarity in the law. So those three things combined really speak to the importance of the bill, and I'd also emphasize what Mr. Doherty mentioned as well, that this bill is by default privacy protective of the user and of those third parties whom which they communicated. So we think it's a strong work product at this point. Would urge your vote. Thank you.
Thank you very much. Other witnesses in support, name and affiliation, if you would.
Madam Chair and Senators, Kevin Gould with the California Bankers Association in support. Appreciate the work of the committee and all the stakeholders.
Thank you very much. Other witnesses in support?
Madam Chair and committee members, my name is Pat Zenzala with KP Public Affairs, and I'm here on behalf of Google, who also supports the bill.
Thank you. Other witnesses in support?
Madam Chair and members, Ivan Altamura on behalf of Yahoo in support.
Thank you, sir.
Madam Chair and members, Ann Blackwood on behalf of Facebook in support.
Thank you.
Madam Chair, Cliff Berg on behalf of AOL in support.
Very good. Thank you. All right. Any other witnesses in support? Witnesses in opposition or neutrality? This means neutral? This okay? Very good.
Chair and members, Dan Pone for the Judicial Council. As the author indicated, we've been working hard over this last year to try to get to a point of legislation that's more workable for the courts and the practitioners that come before them. I'm happy to report that the council has removed its opposition and is neutral on the current version of the bill. Our preference would have been for the broader RUFRADA that takes care of all of the areas that the Model Act covers. But we recognize that this is a big step in the right direction in terms of covering the bulk of the users where these issues will come up. For those reasons, we're neutral on the bill in its present form.
Much appreciated. Those in opposition or neutrality? Are you?
Madam Chair, echoing the sentiments of my colleague, Mr. Pone, have worked extensively with the author, neutral on the bill, still reviewing.
Give us your name and affiliation.
Sorry, Lexi Howard on behalf of the California Judges Association.
Thank you, Ms. Howard. Any other witnesses in opposition? Are there witnesses in opposition? Please step forward. And two witnesses, you can, if you wish to come and testify, you can each give us your 2 minutes worth of expertise and insights. Good afternoon.
Tried to meet that goal. Good afternoon, Madam Chair and members. Kevin Baker from the American Civil Liberties Union of California. We had hoped to be part of that stakeholder group, working hard to remove our opposition and concerns. Unfortunately, we didn't have the opportunity to do so. So we find ourselves here in opposition. So this is a bill that allows technology companies to release our personal information and communications after we die. Is it possible that they might make mistakes, both by releasing too much information or by releasing it to the wrong person? We think that our history of the treatment of digital records it shows pretty clearly that there likely will be mistakes. Unfortunately, we think this bill does very little or nothing to give technology companies an incentive to behave responsibly. For two reasons. It gives custodians sole and complete discretion to decide what digital assets to release, and it gives them complete immunity when they do it wrongly, not only for violations of this law, apparently, but also for violations of any other law, as we read it, including medical privacy statutes and the data breach laws. The only liability they wouldn't be absolved for is apparently direct violation of a court order, which I don't think the legislature is actually free to absolve them of in any event. So this is quite broad immunity. We tend not to favor immunity laws because we don't think that it encourages anyone to conform their behavior to a responsible standard. But taken together, we think that immunity with the sole discretion in the custodian, we're concerned that this combination of gives them no responsibility to, or no incentive to behave with reasonable prudence. So let me acknowledge that not everything that a custodian will be receiving or distributing will be sensitive personal information. Some of it will be totally innocuous, but some of it will be personal information, including electronic communications. And those are, as we know, we believe, qualitatively and quantitatively different than the kinds of records that have traditionally been kept in a paper form. And those records might include medical information, nude photographs, marital affairs, you name it. And please keep in mind that this isn't just information about the decedent, it may also be information about living people. So let me acknowledge here that the bill doesn't authorize public release of digital assets, only release to a person who is, or at least appears to the custodian to be, a personal representative or trustee. But even so, the drafters of the bill, the Uniform Law Commission, understood that release of digital assets to a personal representative can be an invasion of privacy. You have, I think, in your analysis, recited a portion of the comments from the Uniform Law Commissioners, but their report states that access to digital assets might invade the privacy or harm the reputation of a decedent or a protected person, and it might harm the family or business of the decedent or other people.
Thank you. You've gone a little over. There may be some questions. I think that you've made your point. Very good. Thank you. Please go ahead.
Samantha Corbin on behalf of Electronic Frontier Foundation, as well as Privacy Rights Clearinghouse. We were neutral on the previous version of this measure, but unfortunately are now in an opposed position. I won't duplicate what Mr. Baker just said before me, other than to say we've had longstanding concerns with revised UFADA, in which this bill obviously largely tracks. Many of those concerns lie within the definitions themselves, which don't align with the Federal Electronic Communications Act, but are reflected in this bill. You'll see the amendments that have been suggested by the coalition attempt to address many of those. In addition to, as Mr. Baker mentioned, the fact that this measure allows the custodian sole discretion to give up as much information as they wish, of course, including full access to the deceased user's account, should obviously include all digital assets, including but certainly not limited to content, whether or not that information is necessary for a fiduciary to perform his duties at all. While it doesn't require that a custodian turn over deleted data, it certainly doesn't prohibit that either, which means that even information that the decedent expressly intended to be destroyed could still be disclosed to the fiduciary. And it also affords them the discretion to give up no information at all, even if it is necessary for a fiduciary to perform his duties. Then finally, it allows for the custodian to charge the fiduciary a fee to segregate the assets if it elects to segregate them all, which it has the discretion not to do, which arguably is a function necessary to provide access to assets without violating the wishes of the decedent or the privacy of other living third parties. So I'll end there. Thank you.
Thank you very much. Other witnesses in opposition?